everybody. Okay. Welcome. Welcome. I'm here to introduce Mr. Mark Meuser. Before I do, I want to give you a little bit about his background. As an attorney, he is an expert on constitutional law, politics law, election law, and civil rights. In 2024, he served as counsel for President Trump's campaign using his expertise on constitutional law and election law. Mark has also written briefs before the Supreme Court and various courts of appeal. And with all that going on, he still managed to complete multiple Ironman races around the world. Okay, so what brings him here today? He's an avid historian and a meticulous researcher. Today he will be talking about the reasons why the American colonies wanted to break from England, and it's a timely brown bag because he's going to focus on, what's he going to focus on?
The grievances?
The grievances and when our nation was conceived and what led us to that. So without further ado, Mark.
The moment that the United States of America became separated from Great Britain, yes, there is that important moment of July 4th, 1776. But just as each of us has a birthday, we also have a moment of conception. And today, I'm going to talk about that moment of conception where the concept of liberty, of freedom, separate and apart from Great Britain, occurred. Now, I could wow you with the fact of such a great researcher that I found the exact moment of conception of the United States of America. But I'd be lying to you, because someone who was there tells us what that date is, who the individual was, who brought forth the concept of liberty and expounded it in such a way that it sparked the imagination of a nation. So before I tell you the individual who is responsible for us about ready to celebrate 250 years as a nation, I first want to let you know who tells us that this is the moment. This individual, you may have heard of him, John Adams. John Adams, one of the 5 individuals who helped draft the Declaration of Independence. John Adams, the 2nd President of the United States. Late in his life, he was reflecting upon the Revolution and those events that led to us becoming a nation. Because just because we declared our independence didn't mean that we were free, because we had to fight for it. But just because we signed our names on that Declaration of Independence, that is not the beginning of the concept of what led us to become the nation. So John Adams, he didn't point to July 4th, 1776. He didn't point to Thomas Paine and common sense. He did not point to the Battle of Bunker Hill or Lexington and Concord. He didn't point to the Boston Massacre. Some people might think, oh, he's going to point to the Stamp Act. That is the event that a lot of people point at as saying, the Stamp Act was the act that drew the colonies together. But no, he went back a few years before that. He went to the year 1761, the month of February, because something very important was happening in Massachusetts in 1761. We're going to have to step back to 1760, the death of a king. And upon the death of a king, there is a process that must be done where the courts have to reissue the orders under the prior king. And one of those things was called writs of assistance. A writ of assistance was a document that was held by the sheriff. And it gave the sheriff the authority to come to your house and search your house. Now in 1761, because of the death of the king, all the writs of assistance needed to be updated. This was not just in Massachusetts. This had to be done in every single colony of the United States. It had to be done in England. Every colony across the world was going through this process of updating all the legal authority that was happening. Now, one other thing happened in Massachusetts that made this particular set of circumstances unique. What happened in Massachusetts is there was also, about the same time, the death in the Supreme Court justice. And so the king appointed a Supreme Court justice who was responsible for issuing the writs of assistance. And the person that was assigned was a person named Hutchinson. He later became governor of Massachusetts. Now, Hutchinson was the lieutenant governor of Massachusetts, the executive branch. He's now been appointed Supreme Court Justice, the judicial branch. And now, before him are these writs of assistance, which gives power in the executive branch to have searches of any person's property. But who is responsible for the check on this power? The judiciary. So in the only place in the British Kingdom at that time, the judiciary and the executive branch were held by the same person. And this individual was the person who was going to determine, does the executive get all these broad powers? And they came to the lawyer for the crown in Boston, Massachusetts, and said, we want you to go before the court and argue why these broad powers need to be renewed. And he said, no, I'm going to quit my job. And he actually got hired by the Boston merchants. And he argued on behalf of the Boston merchants why writs of assistance were contrary to the rights of an Englishman. For 5.5 hours, he stood at the lectern and explained constitutional principles of what it meant to have freedom and liberty. Now, John Adams was a very young lawyer at that time. And he heard about this important case called writs of assistance. And he sat in the courtroom that day and took notes. In fact, his notes are really the only documents that we have to this day as to what that 5.5-hour presentation was about. Some of the things that this lawyer spoke about that day. Separation of powers. Where have we heard that before? Probable cause. The executive branch should not have the ability to go into your house or your house or your house and search it for whatever reason they wanted to. Because when you had the executive and the judicial branch together working, they're going to deprive you of your rights. If you disagree with them politically, they can make your life a living hell, and there's nothing you can do about it. This lawyer for 5.5 hours got up and explained how our liberties are based upon our security. Our liberties are based upon checks and balances that prevent the government from imposing its way upon us. Government can't do something just because it is easy. Constitutional principles are there to protect us from that overreaching government. These are not arguments that I am making today. These were the arguments made by James Otis Jr. in February of 1761 in a Boston, Massachusetts courtroom. Now, James Otis Jr. was so eloquent, so persuasive, that the judges could not actually make a decision whether they were going to issue the writs. They had to write a letter to the king and say, give us more information about the history of these writs. We need to know what's going on here, because he's making some good arguments that you don't have the authority to be doing this. And so that letter went across the Atlantic. The king saw it. The king's lawyer saw it. They wrote a response. Came back to Thomas Hutchinson. And Thomas Hutchinson granted those writs of assistance. But guess what? Those writs of assistance were never used in Boston, Massachusetts. Because even though the sheriff had the authority now to go into anybody's house, James Otis Jr.'s arguments had spread like wildfire up and down the coast. Everybody understood these principles of liberty and freedom. And any government official who tried to exercise a writ of assistance would have been tarred and feathered and shipped out of town very fast. So while James Otis Jr. lost the battle, he won the war. And late in his life, when John Adams was just evaluating this period where we had gone from the loyal colonist of Great Britain to a people who had not only fought Great Britain once, but twice. When he looked at his entire life, he said, where was the moment that we started thinking like Americans? It was a speech of James Otis Jr. in February of 1761, where he said, we got to stand up. We got to put limits. We can't let the government become so big that in convenience sake, we can let them do what they want when they want to. Now, James Otis Jr. was not a one-hit wonder. Because just a couple years later, 1764, the Stamp Act was brought out. Now, what is some of the provisions of the Stamp Act? Because it's important for where we're going to be going with this. It was a tax upon speech. It was not just a tax. If you wanted to print a newspaper, you had to buy stamped paper. And it would have a royal stamp on it. And when you bought your newspaper, you knew that the paper had been taxed because there was a seal on it. And every newspaper, in order to print and sell, they needed to print it on stamped paper. So it was a tax on the newspaper. It was a tax on speech. But that's not it. You want to send a letter to your family and friends? You had to buy stamped paper. Do you want to get married? Your marriage certificate had to be on stamped paper. Do you want to get a judgment? Somebody owes you money, you go to court, you win a judgment? That order of the court needed to be on stamped paper. The stamp tax was a tax upon not only your speech, but it was a tax on government being able to even function. You were not going to be able to buy property without it being on a stamped paper. Just so many transactions, basic transactions, could not occur absent you paying the government. And so what ended up happening in 1764? The colonists saw this for what it was. And what did they do? They formed the Stamp Act Congress. Delegates from 9 states went to New York. And guess who was there? Otis! James Otis Jr. He was one of the leading proponents of the Stamp Act Congress. And the first thing that they made abundantly clear is, we are loyal British subjects, but we have a right to petition our government. Anybody hear that phrase before? First Amendment? We do not believe that the crown should be taxing our speech, taxing our ability to buy and sell property. This tax violates our rights as an Englishman, our constitutional rights as an Englishman. You are passing laws and taxing us without our consent. We, as the colonists of the United States, do not vote for anybody who goes to Parliament and passes these laws. And since none of our representatives are in England voting on these taxes, it is violating our rights as an Englishman, our constitutional rights as an Englishman, because we did not consent to this tax. If you're noticing by now a trend, some of these problems that we saw, these problems that are leading to the Declaration of Independence, are principles that we now find in our Constitution. Should we go over some of them real quick? Writs of assistance. unwarranted search of Caesar. Where do we find that? Fourth Amendment. Separation of powers. Article 1, Article 2, Article 3 of the United States Constitution. Tax on speech. First Amendment. Right to petition. First Amendment. Many of the things that we see in our Bill of Rights and our United States Constitution can actually be traced to the events that took place in the United States of America from 1761 all the way up to 1776. And the more you understand that period of time, you will understand the grievances that are laid out in the Declaration of Independence, and you will understand our Constitution, and you understand the Bill of Rights. That period of time from 1761 to 1776, the history of what was going on by the tyrannical rule of a king that was trampling upon the perceived constitutional rights of the British subject. Those fundamental principles can be seen over and over and over again as it led to the framework of government of which we enjoy as Americans today. So yes, James Otis Jr. gave the spark to the American Revolution. Then you see him again in that Stamp Act Congress, where for the first time you had at least 9 colonies working together. Because you might have thought, hey, these colonies work together, right? No, they hated each other's guts. But now all of a sudden, there was something that was bigger, that was more menacing. And because James Otis had started expounding the principles of liberty in 1761, now when the problem of the stamp tax arose, that was affecting everybody, they started to see their problem. We have a tyrannical king that is stepping upon our rights as an Englishman. And we need to do something about it. And rather than Virginia do something, and New York do something, and Pennsylvania do something, we're going to join together. And we are going to start talking among each other. And so for the first time in the North America history, you didn't see colonies being divided by the king. The king was actually uniting the colonies. And it started from 1761. The principles that Otis laid out that day went up and down the Atlantic coast. Started telling everybody we need to start thinking about what Great Britain is doing in the terms of constitutional principles. That led to the Stamp Act Congress, which led to the Declaratory Act, where Parliament said, well, you win this one, but we are going to claim for ourselves that we have absolute authority to rule any way we want. Wait a second. Where did we get the 10th Amendment from? You only have the authority that we have given to you. That Declaratory Act of 1765, the Founding Fathers saw that demand that they had ultimate power and said, no, we're going to make sure in our constitutional framework here in the United States of America that a legislative body only has the authority that we give them. So when you look at the 9th Amendment and you look at the 10th Amendment, you only have the power we have given you, and what power we haven't given you stays with the people, stays with the states. James Otis Jr. was an instrumental patriot all the way up until about 1769. Now, in order to help you understand about 1769, we need to go to, I believe it's 1767, the Townshend Acts. The Townshend Acts were a set of acts that basically came in and said, we're going to tax all the imports and all the exports, and the king brought in all these revenue agents into the port cities. And the military came with them. So now, this military that had been situated that had been left there after the French and Indian Wars, now were basically protecting the Revenue Act collectors. And these revenue officials were these new officials who owed their loyalty to the king. Now, if you haven't figured out, Otis was not shy in sharing his opinion. And he was very vocal about how the king was appointing all these new commissioners who owed their existence to the king, not to the local people. They owed their allegiance to this foreign power. And one day in 1769, in a coffee house in Boston, Massachusetts, one of those commissioners was a little upset at something that James Otis had written in the newspaper a couple weeks before, where he was talking about the unconstitutionality of these commissioners. And that commissioner waylaid James Otis in the coffee house. He beat him to a pulp. Just beat the hell out of him. James Otis survived. He actually was able to bring a lawsuit, and he won over 2,000 pounds. But James Otis Jr. was never the same man. He had a few moments of brilliance, but he was basically sent out to pasture to Babel. He saw the Declaration of Independence. He actually survived till 1783, when he was actually struck dead by lightning.
Bad luck.
But the day he got his 2,000-pound judgment out of this commissioner who beat him to a pulp, he said, you know what? I'll forgive you this debt if you make a public apology and admit that you were wrong. And the guy did it. And so James Otis Jr. had a lot of integrity, but he was not there now to be a spokesman for the Declaration of Independence. Those whom he taught now rose up to be the prominent fixtures. People like Samuel Adams and John Hancock learned at the feet of Otis Jr. How many people here have heard of Dickerson? What is Dickerson known for?
He was a Quaker, Pennsylvania, was loyal.
Yeah.
Didn't want to split.
He wrote those letters from the Pennsylvania farmer.
Okay.
Oh,
Pennsylvania farmer, very good. Those were not printed until he sent them to Otis Jr. and said, I need you to look at these. Am I right? Is this appropriate? Nobody in the 1760s was willing to print anything in the colonies about freedom, liberty, and constitutional principles without first getting Otis's approval. Because even though they may not always understand or appreciate his topics, that is the level of respect that James Otis Jr. had in the 1760s. That people like Dickerson weren't even willing to publish the letters from a farmer absent getting Otis's sign off on it. That's a level that you don't see very many politicians today, a level of discretion that you would see. That is who James Otis Jr. was. So while his legacy lived on through the writings of Samuel Adams, John Adams, Thomas Jefferson, even James Madison, all of this flows back to one man. And John Adams, late in his life, said, you know, we got to give credit to James Otis Jr. Now, I'm sure most of you have one of these, a pocket declaration, constitution. I wanted to spend a few minutes here, and I got mine well marked up and stuff like that. But when it comes to the Declaration of Independence, we spend a lot of time on those first two paragraphs in the last two lines. Those last two lines of the Declaration of Independence are so powerful. And for the support of the Declaration, firm reliance on the protections of divine providence, we mutually pledge to each other our lives, our fortunes, and our sacred honor. And many people have written books about what the personal cost was for those people who signed their names to this document. But I'm going to argue today that there is a line that is more important than what you find in the first two paragraphs of the Declaration of Independence or what you find in that last paragraph. And what this one line is, it comes right before you get to the grievances. That part of the Declaration of Independence that we just skim read real quickly, because we don't take the time to understand them. But right before the grievances, it says, to prove this, let facts be submitted to a candid world. Facts. Each of these grievances, to us, it's just a line. What does that mean? But to Thomas Jefferson, to John Adams, Livingston, Franklin, Morrison, to those individuals who signed this document, each of these grievances actually meant something to each of them. And the more you study these grievances and to understand the story of what happened, and then you actually see what James Madison did with the Constitution and the Bill of Rights, the more important you realize how important that phrase is. Because our founding fathers didn't just declare independence for no reason at all. They didn't just do it because we've grown up and we're ready to be independent. Each of these grievances was a violation of what they believed were their rights as an Englishman. A limitation on the crown that the crown stepped over. And by stepping over those boundaries, their rights, their liberties were trampled upon. Now, I'm not going to go through every single one of these grievances. We do not have time, but I have selected a couple of these grievances. And we're going to briefly talk about what was going on between 1761 and 1776. But then we're also going to take it forward to the United States Constitution and the Bill of Rights, of how it went from a grievance that led to independence, that led to a fight, that led to rights being secured, limitations upon our government. So the very first one on this list, he has refused his assent to laws, the most wholesome and necessary for the public good. Now, there are multiple situations. The most prominent one came out of Massachusetts. But the one that I personally believe that this is referring to is something that came out of Virginia. And the reason why I say that is because in 1774, when they first called the Continental Congress, Thomas Jefferson was one of the individuals who was called to the Continental Congress. And he actually wrote a letter stating forth the principles of why this Congress needed to exist. The rights of an Englishman. And in that, he lists a bunch of grievances. And those grievances actually made their way over to England, and the opponents, the supporters of United Colonies, but the opponents of the king grabbed on this letter of Thomas Jefferson. And it got published more in Great Britain than it did here in the United States. But in this letter, he actually goes into a little bit more detail. And this very first grievance comes from this colony of Virginia. Passed laws saying we want to end the importation of slaves into Virginia. And the king, after many, many months, said no. And eventually the king actually passed an ordinance that he sent and said, "Thou shalt not pass any more laws trying to stop the slavery." Because they were being very creative in what they were doing. There were very multiple petitions of what they were trying to do in Virginia to end the practice of slavery. And the king just kept being persistent. This is that first act of grievance. Men like George Washington had been in the House of Burgesses. They passed these laws year after year after year after year. We want to end the importation of slaves. We want to end this practice. And the king refused to end it. Those laws would come to him, he'd do nothing about it. So what did we see when our Constitution came into place? If the king, in our case the president, if the president does nothing within 10 days, it becomes law. If the president vetoes it, they have the ability to overturn the veto. This whole principle of our founding government came from a king that would just sit on bills. So while the Virginians, when they saw this first grievance, they were signing on to it because it meant, hey, we tried to end slavery and they wouldn't let us do it. But this is written so broadly because Massachusetts had its own issues. New York had its own issues. But because we know that Thomas Jefferson drafted the Declaration of Independence and we knew what his prior drafts were, this first one deals with the attempts, the repeated attempts by Virginia from about 1764 to 1774 to try to end the Slave Act. The very first reason in our Declaration of Independence of why we were separating is because the king would not allow the colony of Virginia to end the slave trade. Let's do another one here. He has obstructed the administration of justice by refusing his assent to the laws for establishing judicial powers. And the very next one after that is, he has made judges dependent on his will alone and the tenure of their office and the amount and the payment of their salaries. What do we have in our United States Constitution? We have Article 3. Yes, the president gets to appoint the judges, but judges have lifetime tenure. And so let's go back to Franklin Roosevelt. What did he try to do? Oh, I want to appoint more judges when they get so old or whatever. You got to go back to the fact. Remember, these are the facts of what was going on that led to us declaring our independence. But not only that, how we structured our government. Because what was going on between 1761 and 1774 is that the king started paying the salaries of the judges, rather than what had happened before, is that the legislatures paid the salaries of the judges. So what had happened prior to 1761 is there was some legislative oversight of their judges. They were okay with legislature, with a body that rotates quite frequently, controlling the salary and making sure that the judges were doing right. But what they didn't want is one individual, i.e. the executive branch, being able to control the judiciary. Because what did we see happen in my opening story? When you had Hutchinson, who was accountable to the king to enforce the laws, but also accountable to the king in how those laws were enforced. What happens when you had when you didn't have separation of powers, is you had the ability for abuse of one's political opponents. So, these were facts that led to a Declaration of Independence, a war for independence, but then a structure of government that we still abide in almost 250 years later. So a couple more here. And this is one of my favorites. How many people here know what the Third Amendment is? Go ahead.
It's to prevent soldiers from being quartered in private homes.
Okay. Do you know how many United States Supreme Court opinions have been made about that particular constitutional amendment?
It's not many.
It's the biggest joke among constitutional lawyers is, I've written a book on all the cases about the Third Amendment. I'm a foremost expert on the Third Amendment. There are none. They might have been cited generically for the principle of privacy and the rights of one's home, but there's really no case. There's actually one case, I think it's out of the First Circuit, that ever had to really dive into what this amendment is. However, why is it here? Grievance. For quartering large bodies of armed troops among us. You remember earlier I talked about the Townshend Acts? All those troops that were enforcing the king's tax collectors, where were they staying? They were being quartered. They were being forced to stay in people's homes. What had happened in Boston, Massachusetts, by 1774, most people had no right to their own home because they were hosting a military family, and they had to feed them, do their laundry, and they would, if they got any kind of compensation, it was just based upon the mercies of the soldiers that they were taking care of. The crown did not pay them. It was like, You are taking care of these people. They are sleeping in your house. You had no privacy. You had no right to your home because the king's guards were living in your house. And the more prestigious your house is, the more people you had to take care of. So here was rights as an Englishman being deprived. It led to a declaration, a war. But it didn't make it into the Constitution. But there were several states that said, you know what? We don't want this. We need more protections, i.e. the Bill of Rights. And it's there. You had all the states ratify it. That Third Amendment. You can't quarter troops in your house because your house is your home. It is your place of protection. Because if you don't have that secure place as your home, you have no liberties. Again, going all the way back to James Otis Jr., saying you can't go just search and seize anybody's house for whatever reason. You've got to have probable cause. So again, 1761, 74, 76, 87, 89, to today. Those are fundamental principles. For cutting off our trade with all parts of the world. How many people here have heard of the Commerce Clause? Okay? Who has the power over commerce of the United States? Is it the executive or is it congressional? Congressional. It's an Article 1 power. Why? Because they saw the king using his arbitrary power, shutting off the spigot, not allowing them to trade with each other, the colonies with each other, or with the world. And that's kind of what the whole Tea Act was. It's like, you're going to be trading with the East India Company. You're no longer going to be able to buy your tea from Dutch. Even though Dutch tea is going to be more expensive, we are dictating to you where your commerce is. And they did not want that power to be in the hands of the executive branch. So, it started with a grievance. And when it made its way into the Constitution, they made sure that that power was not in the hands of the executive branch, but is in the legislative branch. And anybody who's been following the news over the last year knows that this power was actually decided by the Supreme Court. And it's one of the few cases that Donald Trump has been shot down by the Supreme Court. I think his record is something like 28-2. But the case about the Commerce Clause, they determined, even though Congress gave the president this power over tariffs, what the Supreme Court eventually said is, wait a second, Congress didn't have that power to delegate it to the president to begin with. These power of tariffs belong to the legislature. And it goes back to the acts by King George over international trade. And the protection that our founding fathers set up was set up through Article 1. For depriving us of, in many cases, of the benefits of trial by jury. Where do you find that in the Constitution? It's in the 6th and the 7th Amendments. 6 is for criminal, 7th is for civil cases. A right of trial by jury. Why? Because the intolerable acts that came out in 1774, the king was so mad at Massachusetts that he set up a whole set of laws that reduced their charter, changed the agreement of which they were even allowed to be a government, changed the charter, shut down Boston as being the center of their form of government and sent it to Salem, Massachusetts, basically everybody who was elected official was all of a sudden unelected, and they refused to set up a new legislature and have elections. The Intolerable Acts was the king's way of just trying to beat Massachusetts into submission. And instead, he actually sparked a Declaration of Independence, because the Intolerable Acts is what led to that First Continental Congress in 1774, which led to 1776. But part of the 1774 Intolerable Acts was depriving people of a jury of their peers. If a king's official did something wrong, well, the trial would be held in England, which meant the trial never happened. And there would be, the king just said, nope, you're good, or whatever. Here's another good one. For transporting us beyond the sea to be tried for pretend offenses. Part of this Intolerable Act was you violated some provision of the Intolerable Acts. You now go stand trial in London. Well, what is a provision in the Sixth Amendment? The Sixth Amendment says that for all criminal offenses, you will be tried in the state and the district in which the criminal offense occurred. Why is that in our Bill of Rights? Because the king was taking people, not Samuel Adams, but he was taking people like Samuel Adams, the rebel rousers. And the way how I'm going to get rid of them is we're just going to make up an offense. And my guards are going to arrest them. We're going to put them on a ship, and we're going to send them to Halifax. And they're going to sit in prison in Halifax until, for 9 months to a year, whatever, because we're going to come down, and all the witnesses have to now go up to Halifax and sit in front of a judge in Halifax. And witnesses how many here would be willing to go, to be a witness for a trial, let's say in Washington, D.C.? How many of you would find that to be very inconvenient for your family, your friends, your work, to just pick up everything and go across the nation just to be a quick testimony for half a day and then go back? That is what was going on. So, part of our Constitution, our Bill of Rights, is the protection to prevent what this grievance was, what the king was trying to do, to apply pressure to bring the people of the colonies into submission. He deprived them of their constitutional rights and just started saying, nope, I'm going to pull you out, because I know that if you're pulled out of here, I hope that the pressure dies down and everybody else will just submit to my will, that I am the absolute tyrant. One last one. For suspending our legislatures and declaring themselves invested with powers to legislate for us in all cases whatsoever. What was part of the Intolerable Acts, as I mentioned earlier, he just came in and shut down the legislatures. And now the territorial or the colonial governor, because there was no legislature, they now just started saying, this is what the law is. Whatever they felt like, and again, the colonial governor was being paid by the crown, was appointed by the crown, so now all of a sudden, the legislature was no more. The governors were doing whatever they wanted to do, whatever they thought, whatever they deemed was best for the people. And now there was no representative government. So, what did our founding fathers do? Very simple. That 10th Amendment. Not only that, there are laws, or not laws, there's in the Constitution, in Article 2, has the ability to determine when the legislature goes out of session, adjourns. It is the legislature. And the only grounds that the President of the United States has to end a congressional session is if the House and the Senate are disagreeing on the date as to when they adjourn. That is, in our Constitution, the only time the President is allowed to adjourn Congress is if there is a fight between the House and the Senate as to when they adjourn. Now, if the House and the Senate have adjourned, and when you adjourn, you set the day for when you come back, and there is something that has occurred, the President does have power to bring them back into session early. The Speaker of the House can't call them in early. When they adjourn, they set a date. So it's the exact opposite. You know, King George said, I'm ending your session and you can't come back in until I tell you. In this case, we have given that power to the legislature to determine when they are in session and when they are not. But if a national emergency or something occurs, the President is allowed to call them into session so that they can act. That is the history of how we have gone from grievances of the violations of our rights as an Englishman to those grievances being put forth in a document that we're about ready to celebrate the 250th year. Principles and facts that we then fought a war for 7 years. And then when we had the opportunity to frame our government, we made sure that those principles of a constitution limiting the government to preserve the rights and liberty of the people, we made sure that those principles of what we had learned from 1761 through 1776, from one despotic, tyrannical king, we made sure that we set forth those principles in a document to ensure that for over 230 plus years, our nation has now become the longest living constitutional republic. Thank you very much.
Do we know much about Otis's history? Did he go to college? Did he read Montesquieu and Hobbes and things like that? Did he talk about his...
He was a lawyer. He was very well educated. He came from a very prominent family. In fact, Otis's father, most people thought he was going to be the Supreme Court justice that the king was going to appoint. That's how the Otis family was very, very, very prominent. A little bit more about Otis's family. His sister married a guy named Warren, and Warren is one of the prominent figures in our history over... How many people have heard of the letters of correspondence? That's Warren. So this Otis family was very well connected. They were very politically active. Mercy Otis Warren has written, according to my perspective, probably one of the top histories of the American Revolution. I will not say she's the best because she's very Massachusetts focused. There's a couple others that I've read from who wrote about it at that time in history, who had more of a, all colony perspective. But because Massachusetts was kind of the spark of this whole thing, her histories of the American Revolution are some of the best out there. So,
Got a question. So Wilberforce gets credit in England for abolishing slavery or leading to that, 1830, whatever.
I think it's 33, but 31 or 33, I can't remember.
Yeah, 33, 1803 they abolished import.
Yeah.
Was he is there any connection between him and the people in the colonies who were trying to abolish slavery and import as well?
Wilberforce was a very, he had a lot of connections in the United States. His writings of what he was writing that was sparking the movement in Great Britain were well read in the United States. I can't tell you who the figures were. I've read it in the past, but off the top of my head, I don't remember the figures. There were multiple people in the United States, House and Senate, who were making the same arguments at the same time that Wilberforce was making, and ideas were cross-pollinating. So I can tell you that.
Yeah. And then one of the things I was just reading the other day that I thought was kind of interesting, they were talking about, the taxes and how today we're taxed like a lot, right? And someone's comment was something like, we went to war with England over a 2% tax.
Yes.
Is that kind of accurate?
I don't even think it was a 2% tax. I think it was, when you actually consider the whole portion of your income, I mean, it was like a 2% tax on tea.
On things you bought.
On one or two items.
Yeah.
So when you think about what the tax was over your entire income, I've heard numbers as low as like 1/8%.
Yeah. So when I give tours, I go through the Constitution and the Declaration, because I kind of point to some of these things and say, remember we split from a country and had a war over less than 2% of a tax.
Yeah. Yes.
Were the sheriffs in colonial America royal appointees?
No and yes. There was a transition that kind of happened. The sheriffs in 1761, because prior to 1760s, prior to the French Indian War, the colonies were pretty much left to themselves. And what happened with the French Indian War, and Thomas Jefferson talks about this, or briefly mentions this in that letter I was talking about in 1774. One of the things he said, where the king departed from the north, is like Portugal had a problem with some pirates. They asked for assistance from Great Britain. Great Britain came, they fought, because it was mutually beneficial to both parties for this problem to be taken care of. The colonies had a problem with the Indians. They did request Great Britain's help. Because why? If you help us put down this insurrection, what we'll be able to do is our trade will be able to pick back up again, and your merchants are going to be rich. This is a mutual beneficial thing for you to do. And what Thomas Jefferson says in this letter of 1774, he said, had we known that this support that you would have given us would have come with all these strings and would have been depriving us of our rights, we would have told you hell no. Slight paraphrase. But I mean, that's what Jefferson said. We never would have allowed you to come in with your troops and help us. And he cites to this Portugal example. It says, hey, you went in, you helped Portugal, and you left. They didn't lose their rights. They didn't lose their freedoms. They didn't lose their liberties. So prior to the French Indian War, prior to the end of the French Indian War, sheriffs would have been elected locally. They would have got their compensation locally. It was a very local government. Between 1761 and 1776, you see this escalation going on. And while the sheriffs may have been still loyal to, appointed by the legislatures or by the people and paid by the people, they basically became obsolete. Because what ended up happening is the military basically became the enforcer of a new set of laws. So you kind of had this dual government going on that, yeah, the sheriff had nominal authority and was nominally, was paid by the colonies. But the real problem was the British military enforcing military law. So in some ways, you know, it's a separation of government, but the sheriffs were no longer the problem. The problem was the abuses going on by the military and the military justice.
Were there laws against unlawful assembly during that time?
Yes.
I mean, like when the founders got together to discuss the Declaration of Independence, was that act of insurrection or an unlawful act considered by the Crown?
Yes, it was part of the Intolerable Acts was a provision that basically shut down town assemblies. I mean, the whole Continental Congress was illegal.
Yeah.
And it was done right under Hutchinson's nose, and Hutchinson knew it. But it's just, you know, what happened in the Boston massacre kind of, you know, had people living in a lot of tension. Even though Boston was 1770, the Boston massacre, you gotta understand we're 1774, 4 years. Everybody knows what happened there. And so, yes, it was illegal. They weren't supposed to do it. Hutchison tried to, you know, talk with people, no, you can't do that. And they kind of said, we're gonna do it anyways.
Right on.
You know, there was some backroom attempts and everything to try to solve it. What they were doing was violating what the king had told them they could do, but they did it anyways. Because, and a lot of it goes back to the Boston Massacre, if he pushed his power so far, what was going to end up happening is he would have been tarred and feathered and run out of town. And there were multiple times between 1770 and 1774 that the governor of Massachusetts was exiting out the back door as his gate was being broken in the front door. And there were many tax collectors who found themselves literally tarred and feathered. So you know, yes, Great Britain had a large military, but at the end of the day, there was only so many people in Boston, and you know, understand that the Boston troops were young men who probably had their eyes for some of the fairer young ladies of the community, and that's the young lady's father who's coming. Do you really think that they were going to raise up arms or something like that? Their life goes on, and so quite often the military that was stationed in front of the governor's house, they would just hold it long enough so that the governor could escape out the back door and be gone for a week or two. And then they would step aside and they'd let them trash the house, you know, pretty big. And so the governor had a lot of authority, but he didn't have, if he valued his life, he didn't enforce everything. And that's kind of back to that opening story of writs of assistance. As the people became educated, as the concepts of liberty were being expounded and, you know, and people were understanding these topics, the governor was in a losing battle. The king was in a losing battle. Could it happen in today's world where instant communication? Probably would be completely different. But because we had an ocean apart, the king didn't listen to the people because it's just the colonies. You know, we've put down riots over the last 100 years in India and everywhere else. You know, this is just going to be put down. But what he didn't understand is that what happened in February 1761 is that a large portion of the population started thinking about what the government was doing in the framework of constitutional rights, being the Constitution is what protects me from my government. And that awakening of the people of how my rights are being violated by the government means I have to do something about it. Well, I don't know how long I've gone. I think I probably have gone over, but.
Yeah, thank you, Mark. Incredible.
as my heart beats true for the red, white, and blue, where there's never a foe.